Hi, this is Bob Palmer from Housing Action Illinois, and I'm here with Andrea Kovach from the SHRIVER Center on Poverty Law. Thanks for participating in today's webinar for the next hour, which will be an overview of the public charge and admissibility rule. There's been some recent developments just in the last day or so that Andrea will update us on. To take a couple housekeeping questions and most common questions on webinars, to get those out of the way. Yes, we will be sending out the slides afterwards, and we're also recording the webinar, and it will be posted on our YouTube channel. So even those people who signed up and didn't participate in the webinar, or colleagues of yours, would be able to see it. Also, we're planning on holding questions until the end because there's a lot of material to cover, and maybe a lot of the questions that will be answered during the course of the webinar, but we'll make sure to leave time at the end, before the end of the hour, to go over the questions. So with that, we'll just turn it over to Andrea, and you can start.
Thank you very much, Bob. I'm happy to be here. Again, my name is Andrea Kovach, and I'm a health justice attorney at the SHRIVER Center on Poverty Law. And the SHRIVER Center on Poverty Law is located right here in Chicago, Illinois, and we fight for economic and racial justice. We have been around for over 50 years, and we litigate, we shape policy, we train and convene multi-state networks of lawyers, community leaders, and activists nationwide. So if you want more information about the SHRIVER Center, please see our website at povertylaw.org. So as Bob said, today we have about an hour for me to provide an overview of the public charge and admissibility rule. So first I'm going to start with a timeline of when this public charge rule first was introduced into the public ether. And we're going to spend a fair bit of time on that because we do, as Bob said, have some new developments from the last 24 hours or so about the timeline of this rule. Then we're going to spend a fair amount of time on who is even subject to the public charge rule, because that is so important for you to be informed and to be able to impart that information to all of the clients that you serve. Then once we talk about, after we're done explaining who is actually even subject to this rule, we're going to say, okay, now what is this test that's within this rule? And we're going to need to talk about the test that has been in effect since 1999, as well as the test that was introduced by the Trump administration that was supposed to go into effect on October 15th of this year, but has been right now blocked by the courts. Then we're going to spend a brief amount of time talking about the impact that the public charge changes to the public charge rule have had, and as well as will have when the rule goes into effect. And then we'll spend a brief amount of time talking about messages for you all to provide to community members about the public charge for inadmissibility. If we have some time, I did want to just let you know that there are a couple other developments on the immigration front that it's good that you know about at a very high level in case clients are talking about them to you. So we're going to talk about the executive proclamation requiring immigrants to have health insurance that was issued on October 4th, as well as what I'm calling the fee hike rule that was introduced a few weeks ago, and that is still in a comment period mode. And then we'll finish off with resources for you to have for information about public charge, and then the rest of the time will be questions and answers.
And before you get going on the next slide, Andrea, if I could just say, remind people, if you do have questions or comments about the quality of the audio or anything, you can type it into the control panel that you should have on your screen. And we did already get another question about the slides, and yes, they will be available afterwards. We'll email them out to everyone. So thanks.
Great. All right, with that, let's talk about the new public charge rule. So it's important for you all to understand that the public charge rule was first leaked in an executive order that previewed in an executive order back in January of 2017. And so you can see that we've had a couple years now where immigrants across our country have heard that there were going to be changes to the public charge rule, which has created confusion, fear, and panic about those changes ever since January of 2017. Then a year later, the Department of State changed the Foreign Affairs Manual. And the Foreign Affairs Manual is the guidebook that consular officers abroad use when visa applicants who live abroad and want to apply for a visa to come into the United States. The Foreign Affairs Manual is what immigration officials or consular officers use in deciding whether someone can in fact be granted a visa. And it's important here because Department of State back in January of 2018, they went ahead unilaterally and made changes to the public charge test for those visa applicants all the way back in January of 2018. Then moving forward in October of 2018, that's when the Department of Homeland Security published a proposed rule making changes to the public charge for inadmissibility test, which is what we're going to spend the bulk of this presentation talking about. And that proposed rule was filed on October 10th. It opened up a 60-day comment period, which closed on December 10th of 2018. During that period of time, over 266,000 comments were filed in the Federal Register. The vast majority of those comments, I think almost 9 out of 10 of those comments filed were in opposition to the rule. And we know that because when the Department of Homeland Security published the final rule in August 14th of 2019, they indicated in that final rule that, in fact, the vast majority of comments issued were in opposition to the rule. Nevertheless, the rule was published on August 14th, 2019, and in that published final rule, an effective date was stated that the effective date would be October 15th of 2019. But what happened was on October 11th and October 14th of 2019, before the final rule could take effect, federal courts across the country issued injunctions blocking the final rule from actually taking effect on October 15th, 2019. So, October 15th, 2019, the final public charge rule that we're going to be discussing today did not go into effect. And we do not have a new effective date for the public charge rule, which we'll talk more about, but there is no new effective date yet. So let's talk a minute about the lawsuits that challenged the rule. So as soon as that final rule was published in August of 2019, that provided the opening for lawsuits to be filed challenging the public charge rule for inadmissibility. And like I had said, on October 11th and October 14th, by those two dates, we had actually had over 9 cases across 5 states, with injunctions being filed in all of the states that you see here, blocking the public charge rule from going into effect. In fact, all 5 courts blocked the rule. So 3 federal judges at the district court level in New York, Washington, and Maryland issued preliminary injunctions that apply nationwide. And in Illinois, here in Illinois, the Illinois Coalition for Immigrant and Refugee Rights, or ICER, and Cook County were organizational plaintiffs, where a lawsuit was filed in district court here in the Northern District of Illinois, and that judge issued a temporary injunction blocking the public charge rule from being implemented in Illinois. So it was not a nationwide injunction. The injunction blocked the rule from being implemented just in Illinois. So what does this mean? Well, right now, the federal government, who is the defendant in all of these cases, is appealing all of these injunctions. The Department of Homeland Security's public charge and admissibility rule remains blocked unless or until a court grants a stay or lifts all of those injunctions. So again, what that means is there is no effective date right now for the new public charge rule, but if the injunctions are overturned in the future, there will be a new effective date, but we won't know it until then. But any of the newly listed public benefits, which we're going to talk about in a minute, from the new proposed rule, any of those new list of benefits received before this new effective date will not be considered. So as of today's date, so speaking of all of these injunctions, as of today's date, two of the three nationwide injunctions have been lifted. So if you look at the green box down at the bottom of the slide, the Ninth Circuit Court of Appeals, which was the court that was reviewing both the Washington case and the California cases, and the Fourth Circuit Court of Appeals, which is the appellate court reviewing the case that came from Maryland, they have now both issued rulings lifting the nationwide injunctions. There is still a remaining nationwide injunction in effect from the court case from New York, and the Second Circuit Court of Appeals is reviewing that right now and is expected to issue its ruling any day as to whether to preserve the injunction or to lift the injunction. So bear with me on these next few slides. It's going to be a little complicated. So right now, what is next is, so each circuit, so the Fourth and the Ninth Appellate Court circuits, those court cases were decided by three judges that are sitting at each of those appellate court levels. But each three-judge panel does not constitute the entire panel of judges on that appellate court circuit. So the plaintiffs, the litigants in the case, could ask the Fourth and the Ninth Circuit Courts to have their entire panel of judges, which could be 11 judges or 13 judges, to do what's called an en banc review, to review the injunction. So for instance, the California litigants, who are now, their case is in the Ninth Circuit Court of Appeals, where they just lifted the injunction, three judges lifted that injunction. They could ask for the entire panel of judges who sit in the Ninth Circuit Court of Appeals to do an en banc review. And so we're waiting right now. This has just happened in the Fourth and Ninth Circuit, so we're waiting to see what the litigants in those cases will do. As to the Second Circuit Court of Appeals, and again, that's the appellate court that is hearing the cases from New York, if they issue a favorable ruling preserving the nationwide injunction, then what we would have is we would have two circuit appellate courts lifting the injunctions possibly, and we would have the Second Circuit preserving the injunctions. So there would be a split at that level. And so at that point, we could see the federal government asking for an en banc review for the Second Circuit Court of Appeals for the same reasons I just described about the Fourth and Ninth Circuits. Or we could see the federal government just saying, you know what, we just need the U.S. Supreme Court to take this case to just take the entire, all of these cases and expedite it to the U.S. Supreme Court. So as you can tell, there's a lot of moving pieces, and it is literally evolving every hour. But I did want to provide you all with the most up-to-date information about where we sit right now at 2 p.m. Central Time on December 10th, 2019. So we're waiting for the Second Circuit Appeals Court to rule on whether they're preserving the injunction or lifting the injunction. But remember, as long as the injunction remains in place, the public charge rule is still blocked from being implemented. The new public charge rule is still blocked from being implemented. And then, don't forget, here in Illinois, there's still a court case pending here in Illinois. So the Seventh Circuit Court of Appeals is going to be reviewing the injunction that was issued by the district court judge in the Northern District of Illinois. So this injunction is still in effect for Illinois. So all of the legal proceedings that I've just described have all been legal proceedings regarding trying to achieve and to get the injunctions and to preserve the injunctions. But as far as actually the merits of each case, those arguments will probably happen this coming spring is our best guess. And then I did want to just spend a second on the scenario is, well, what happens if the Second Circuit Court of Appeals, which is, again, the last is the last nationwide injunction, what happens if they do issue a ruling that lifts the injunction? We don't know, again, when that new effective date for the rule would occur. So the new effective date for the new rule could be the same day that the injunctions are lifted, or the court could set a future effective date. So again, we just don't know. But for those of you who are thinking, well, what happens if the Second Circuit Court of Appeals lifts the injunction? Does the rule take effect that date? We still don't know. It could, or it could set a future effective date. However, the Northern District Illinois injunction would still block the rule from taking effect in Illinois while we're waiting for the Seventh Circuit Court of Appeals to rule. So again, lots of moving pieces. It's evolving. Just wanted to give you the most up-to-date, accurate information. But that's why it's so important that this training is happening and that you are on this training right now. Because the most important thing that you can do right now is to get the facts about what is in this new public charge for inadmissibility rule so that you can help combat the fear that families across Illinois, across our country are feeling about this rule, so that families, when they get that accurate information, they can make the best decisions for themselves as to how they want to proceed. And that's why it's so important right now that you stay connected to a reliable source of information, such as Housing Action Illinois. And so now we're going to learn what is in this public charge for inadmissibility rule. So as I said earlier, one of the most important foundational questions for you to really have a good understanding of is who is even going to face the public charge inadmissibility test. So the three big buckets of people who will face this test, who will be subject to the public charge inadmissibility test, are when folks who are outside the United States, when they are applying for a visa or a green card to enter the United States. When they are seeking to enter the United States, they will be subject to the public charge test at that consular office abroad as a contingency as to whether or not they get that visa or get the green card to enter the United States. The second bucket of people who will be directly subject to this test are people who are applying for their green card or lawful permanent resident status. When they apply for that green card, they will be subject to the public charge test. And then the one situation when a green card holder, so somebody who already has their green card, could be subject to this public charge for an admissibility test is if a green card holder or LPR leaves the United States for more than 180 consecutive days when they seek to re-enter the United States on, let's say, the 190th day. They will be subject to the public charge test again at that consular office. So the public charge test does not apply to everyone. So here on the right side of the slide, you can see people who will not be subject to the public charge test. So when lawful permanent residents or green card holders are applying for citizenship, they will not be subject to the test. Refugees, asylees, VAWA self-petitioners, T visa holders, U visa holders, as long as they're using that status, one of these humanitarian statuses when they apply for their green card, they will not be subject to the test. They are exempt from the test under statute that cannot be changed by these new proposed changes to the public charge rule. Same with special immigrant juveniles, some parolees, and other humanitarian immigrants, but I wanted to provide the largest categories of those who are exempt from the public charge test. And again, this is in statute and cannot be changed by the new proposed changes to the public charge rule. So who is most affected by the public charge inadmissibility rule? So those who are seeking their green card based on a family relationship. So these include spouses, children, and unmarried adult sons and daughters of a U.S. citizen or someone who already has a green card holder, and the parents, siblings, and married sons and daughters of a U.S. citizen. So if you're thinking to yourself, well, how many people per year are applying for their green card based on a family relationship? So the Migration Policy Institute has issued data showing that approximately 2/3 of the 1 million non-citizens who obtain green card status every year, they base it on a family relationship. So for those of you who are thinking about documented folks, does public charge apply to DACA recipients? There is no public charge test or no public charge assessment when a person is renewing their DACA status. However, DACA recipients are not exempt from public charge. So if a DACA recipient obtains a pathway to becoming a green card holder, such as, again, through the family immigration pathway by marrying a citizen, they would be subject to a public charge test unless the pathway that they have is an exempt pathway, such as a U visa. So a DACA recipient who is applying for their green card using a family immigration pathway and not one of those exempt humanitarian statuses would be subject to the public charge for inadmissibility test. Will the public charge rule affect immigrants who are already green card holders or U.S. citizens? I wanted to create a slide on this because we get these questions very often. The public charge rule does not affect individuals who have already become U.S. citizens. Green card holders or legal permanent residents, LPRs, are also not subject to a public charge inadmissibility test when they apply to renew their green card or when they apply to become a U.S. citizen. The only instance where green card holders could be subject to the test is if they leave the United States for more than 180 consecutive days when they seek to re-enter the United States. After that 180-day period, they would be subject to the test at the consular office. Okay, so we're going to talk about the current process if an application is processed inside the United States. So we're talking about immigrants who are residing inside the United States right now, and they're seeking their green card. They're applying for their green card. What is the current process, and how does public charge fit in? So it's easiest through an example. So here I have an example of Rosa. So Rosa entered the United States on a tourist visa. So she's here in the United States on a tourist visa. She went through a legal checkpoint. She has legal papers to be in the United States, and she meets and marries a U.S. citizen. Now she's applying for her green card through the family immigration pathway via her U.S. citizen spouse. So she's not one of those humanitarian statuses that I spoke about earlier. She's not here. She doesn't have a U visa status, a T visa status, a VAWA self-petitioner status, any of those other statuses she does not have. So when she's applying for her green card using the family immigration pathway that is open because of her marriage to her U.S. citizen spouse, she will be assessed under the Department of Homeland Security's Public Charge ground for Inadmissibility Test. So that's who we're talking about when we say if the application is processed inside the United States. So right now, as of December 10th, what is the test that Rosa will be assessed under? So we're going to spend a minute, I know there's a lot of text on this slide. We're going to spend a minute talking about the public charge test that has been in effect since 1999, that is very narrowly defined, and because the Trump administration's proposed changes to the test has not gone into effect, remember they were supposed to go into effect October 15th, but they didn't. This test that you see on this page, this slide right here, this 1999 test is the test that is still in effect today. So if Rosa, in my example, is having her interview with immigration officials today, this is the test that Rosa will be assessed under. So immigration officials will look at Rosa's green card application and they will say, is Rosa a person who is considered likely to become primarily dependent on the government for subsistence? And immigration officials are allowed to consider two public benefits when they're making this assessment as to whether Rosa is likely to become primarily dependent on the government. The immigration officials are allowed to look at, has Rosa received cash assistance for income maintenance, so SSI, TANF, general assistance, or has Rosa been institutionalized, or is she being institutionalized for long-term care at government expense? So the best example of that is Rosa in a nursing home and it's being paid for by Medicaid. Immigration officials are also supposed to assess Rosa's age, health, family status, financial status, and education and skills, which I've listed here in the gold box that's listed totality of the circumstances. In practice, what immigration attorneys will tell you and have told me is that if the green card applicant has a sufficient affidavit of support, it's given great weight by immigration officials, such that that is normally all that is needed to pass the public charge test, to not be found a public charge. So for those of you who are wondering what an affidavit of support is, an affidavit of support is a contract that a sponsor, usually a family member, signs to accept financial responsibility for an applicant and his or her dependents. So in our Rosa example, Rosa's sponsor could be her U.S. citizen spouse. It could be her U.S. citizen spouse and another family member. She could have two sponsors if she wanted. And so the biggest takeaway for you to know is that this test that has been implemented since 1999 is a very narrow test. Immigration officials are only allowed to look at two types of benefits, which I've listed here. And because the test is so narrow and because it is calibrated in a reasonable and rational way, immigrants pass this test. Green card applicants pass this test, and very, very, very few are ever found to be a public charge. And you may be asking yourself, well, what is the legal consequence if a green card applicant is determined a public charge? What happens? Well, if a green card applicant is determined a public charge, or a visa applicant is, then that person is denied their visa or denied their green card. So they're effectively kind of kicked off the pathway towards not only getting the green card or the visa, but effectively kicked off the pathway to becoming a citizen. So unless they have another way to become a green card holder, that kind of ends their journey to getting their green card and moving towards citizenship. So it's a obviously serious legal consequence to be determined a public charge. So now we're going to talk about, well, what are these changes that the Trump administration is seeking to make? What was in this final public charge rule that was set to go into effect on October 15th of this year, but has been blocked by these injunctions? So we're going to spend a fair amount of time talking about these new changes so that you have an understanding of what it is that immigrants have been fearing since 2017, and that what actually could go into effect if the nationwide injunctions and the Illinois injunction are lifted. So first, I wanted to show you that in the new public charge rule, the Trump administration is seeking to greatly expand the definition of who is a public charge. So they're seeking to expand it so that a public charge is defined as someone who is more likely than not at any time in the future to become a public charge based on the totality of the circumstances, which we're going to talk about in a minute. A public charge is a person who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period, such that, for instance, receipt of 2 benefits in 1 month counts as 2 months. So if you're receiving SNAP and housing assistance, for instance, in 1 month, it actually counts as 2 months towards that 12-month period of time. And it's not, this new expansive definition of public charge doesn't just look at who is receiving these benefits right now, but it actually is requiring immigration officials to do a future speculative determination of whether or not the green card applicant at any time in the future, even after they receive their green card, could receive one of these public benefits for more than 12 months in the aggregate within any 36-month period. So it's a much, much more expansive definition than the definition that is currently in effect from 1999, which is on the left side of the slide. And so in addition to the greatly expansive definition of public charge, the Trump administration is also seeking to add 5 new public benefits to the public charge test. Medicaid, except for the exceptions we're going to talk about on the next slide, food stamps, Section 8 Housing Choice Voucher Program, Section 8 Project-Based Rental Assistance, and public housing. So the Medicaid benefits that were excluded from the new public charge test are Medicaid for children up to age 21, which in Illinois is the All Kids program, Medicaid for pregnant women, which in Illinois is the Moms and Babies program, emergency Medicaid, and Medicaid for school-based services. So the Medicaid that is included in the new public charge rule would be ACA Adult, the Medicaid Expansion Medicaid, Family Care, and other Medicaid programs that are not listed on this slide of excluded programs. So how does the final blocked rule affect the use of housing and homeless assistance programs? The rule explicitly includes only those 3 federal housing programs, which I've listed here again, and the National Housing Law Program states that the rule would cover Section 8 Moderate Rehabilitation Program, and although the final rule does not address this issue, other federal, state, and local housing programs may be implicated where there's layers of subsidies from one of those above programs, the Section 8 Housing Choice Voucher Program, Project-Based Section 8 housing assistance and public housing, where those are used to make units affordable. So what housing and homeless assistance programs are excluded from the public charge test? I won't go over all of them, but I've listed them here. I do want to draw your attention to homeless assistance programs are excluded. Section 515 rural housing programs excluded. And again, you're going to get a list of all these slides so that you can refer back to them. For those of you who are wondering, okay, well, when I think about which immigration categories are even eligible for these programs, what does that overlap look like? And so I did want to provide a slide here that shows which immigrants are eligible for which section or which housing programs, which I'm not going to go over in great detail, but you have it here. But I do want you to remember that the public charge test is much more broader than whether or not a green card applicant is actually used these programs, as you'll see when we talk about the totality of the circumstances test. Other programs that are excluded from the public charge test, I've listed them here and on a couple other slides so that you have them for your own reference. When you get questions from clients, well, should I disenroll from WIC because of public charge? You can answer them that WIC is not included in the public charge test. This is another slide of programs excluded from the public charge test so that you have it if clients are asking you questions about these particular programs. And even more benefits that are excluded just to have for your reference. For those of you who are wondering, well, what about the green card applicant's family members? So let's go back to my Rosa example. When Rosa is being determined under the public charge test by an immigration official, immigration officials will only look at Rosa, the green card applicant's use of public benefits, and not her family member's use of public benefits. So in addition, there is still that totality of the circumstances test in the block new rule. And in fact, it's been given much greater weight by the immigration officials in this new test that's been proposed by the Trump administration. So in the new public charge rule, the sponsor's affidavit of support is no longer given great weight. It's been demoted in weight to just one of many factors. Instead, immigration officials will be asked to consider whether the green card applicant's age will impact their ability to work. And if they're under 18 or over 61, it's considered a negative factor in the new test. Family status, immigration officials will also look at whether the green card applicant is able to financially support everyone in their family, and if not, it's considered a negative factor. Green card applicants will also be asked to provide at least 3 years of tax returns. They'll need to show that they have a high school degree or higher, or it's a negative factor. They also need to show proficiency in English under this new public charge test, or it's a negative factor. For health, the green card applicant will need to show that if they have a health condition that might cause them to need medical treatment, they need to show that they have access to private health insurance. If they do not, it's considered a negative factor. And this is where disability is considered here. Immigration officials will review whether someone has a disability that could affect their ability to work or to attend school full-time. And if they do, it could be considered a negative factor. Immigration officials will also look to see if a green card applicant has at least 125% of the federal poverty level in household income. If they don't, it's a negative factor. They also need to provide their credit score and credit history, and under this prong is where use or applications for public benefits comes in. So you can see that there's so many factors in the totality of circumstances test that are now being given great weight, that a green card applicant like Rosa could have never used public benefits and still be determined a public charge because there's about 15 other factors to look at. Basically, if she's low income and she has a health condition, if she has low credit score, right there she could have at least 3 negative factors against her without ever having used public benefits. ROSA and green card applicants will be required to provide all of this information about the totality of the circumstances test on a new form called the I-944 form. And that form right now has been blocked from being implemented, but if there is a new effective date for the new public charge rule, then the I-944 form will go into effect. And that's where the green card applicant will need to provide all of the information that I've just discussed in the totality of the circumstances test. So the current policy if the interview for status is outside the United States, we're not going to go over it too quickly. I've already mentioned that this is where consular officers abroad are applying the public charge test, and that this has gone into effect back in January of 2018. So here's an example of when this would happen. If grandma who lives in Vietnam, she's a Vietnamese citizen, she's applying for a visa to come to the United States to stay with her family who lives in the United States. That's when this other public charge for inadmissibility test from outside the United States comes into play. And so that has already changed back in January of 2018. I did want to let you know that those changes did go into effect back in January of 2018, and it did broaden all of the totality of the circumstances that consular officers can consider. And so far, we've seen public charge denials from outside the United States increase. You can see here from 1,000 in fiscal year 2016 to 12,000, our most recent data. So there's been a huge exponential increase in denying visas to mostly low-income visa applicants. So if you want more information about that, I can provide that to you. This last slide just provides a recap of the current public charge test if you're applying from inside the U.S., like ROSA, or from outside the U.S., like a visa applicant. So impact. As you can already tell, for those of you who have been following public charge, the impact will be felt most harshly by those directly affected by the public charge test, who will be directly subject to the rule, like the ROSAs. But also, since January of 2017, a broader population of people have been subject to the chilling effect of this rule. So confusion, fear, and panic since January of 2017 has caused people who are not even subject to public charge to disenroll from programs that they're eligible for, or to disenroll their family members from programs that they're eligible for. And we know that so far, just from that chilling effect, and which will only get greater if the new public charge rule goes into effect, that there'll be increased rates of homelessness, unstable housing, the diminished access to health coverage such as Medicaid and SNAP, which we all know are work supports, will make it difficult to pay rent or remain in private housing, as well as there just being an administrative burden on all types of housing providers, both the chilling effect from the confusion, fear, and panic from this rule, as well as when this rule, if this rule does actually take effect. Here are some statistics from the Illinois Department of Human Services projecting disenrollment from Illinoisans in Medicaid and from SNAP coverage due to the chilling effect of this rule and from being subject to the test. So messages for community. So right now, it's so important that you all know that that's why we spent so much time on it. You need to provide accurate information about whether the public charge test actually applies to the people that you're talking to on the phone, or that is across from you at your desk, or that you're meeting in your offices. So if the families that you're talking to are already U.S. citizens, if they already have green cards and have no intent to leave the country for more than 6 months, or have one of these humanitarian statuses, then they should continue to enroll in programs they're eligible for. They are not going to be subject to the public charge test. If the person you're talking with plans to apply for a green card or for a visa from inside the United States, as of today's date, that 1999 test is still in effect. And so only the use of that cash assistance and long-term care programs will be considered in the public charge test. Obviously, please stay connected to a reliable source of information because that could change any day. But right now, those folks should continue to stay enrolled or enroll in programs that they're eligible for. And for those that are planning to apply for a green card or visa from outside the United States, they should talk with an immigration expert first. So I've listed a couple questions here just to give you an idea of how to answer them. So we'll go to the second one. My brother is applying for citizenship but uses Section 8 housing voucher. Is he a public charge? So the answer could be the public charge test does not come up when people apply for U.S. citizenship. So that's number one. Section 8 housing vouchers are not considered in the public charge test that is in effect right now. It is included in the public charge test that's currently blocked by the courts, but since your brother is applying for citizenship, public charge does not apply anyways. So really quickly, I'm going to breeze through these super fast. I did want to mention the October 4th executive proclamation as well as the fee hike rule, and then we're going to be able to take questions. So back on October 4th, the executive branch of the government issued a proclamation requiring certain immigrants to have health insurance before they could enter the United States. So it basically applies to people seeking immigrant visas from abroad. And the proclamation basically stated that within 30 days of entering the United States, these visa applicants have to show that they have approved health insurance or they are wealthy enough that they could reasonably pay for their foreseeable medical costs. No procedures were actually issued for how consular officers would actually determine this, and the policy was so vague, it didn't even state how immigrants would be able to prove they meet the requirement. Not only that, but all of the approved health insurance under this proclamation included health insurance that would not necessarily be available to a low-income visa applicant. So employer-sponsored plans, for instance, were approved. Medicaid was only approved for children. And then this proclamation applied to anyone that would be issued a visa after the effective date of the rule. So here's a list of those that would be exempt. So for you all to know, right now this proclamation is actually being currently blocked from going into effect, but just like there's movement every day in the public charge cases, this injunction issuing this proclamation from going into effect could be lifted at any time as well. So right now it's not in effect, but I did want you to know that it is out there and visa applicants could be subject to this insurance requirement at a future date. The fee hike rule. So this is a new proposed rule that was published in the Federal Register and that has a comment period until December 30th. And in effect, it drastically increases the cost of applying for immigration benefits. So just to give you an idea, under this new proposed rule, it would increase the cost of naturalization to become a citizen from $640 to $1,170, which is an 83% increase. It would also, for the first time ever, impose a $50 fee for asylum seekers. According to the Coalition for Human Needs, only three other countries in the entire world charge asylum seekers a fee, and the Trump administration is seeking to do that with this new proposed rule. And it would also increase the cost for people to renew their DACA from $495 to $765, among many other things. So I just wanted to let you know about it. I've listed information at the bottom of the slide where you can learn more about it, and please comment in opposition to the rule before December 30th. Resources. So first I wanted to let you know that Protecting Immigrant Families Illinois, a coalition that is very diverse, you can see on the right-hand side of the slide here, including Housing Action Illinois, how diverse our table is of steering committee members. We were formed in the spring of 2018 specifically to educate and resist on this rule. So if you would like to learn more about our coalition, to request a training or a webinar, fact sheets, get updates on the public charge rule and all of the changes to it, please email us at pipillinois@povertylaw.org and we will add you to our listserv. Also, HelpHub is an online technical assistance portal that the SHRIVER Center and our sister organization runs that can help answer any questions that you might have about connecting your clients to Medicaid or marketplace coverage, or to answer any of your public charge questions. We have an immigration attorney who can answer public charge questions as well. And all you have to do is go to helphub.povertylaw.org and click on this short form for like a 30-second registration for you to become a HelpHub registered user, and then you can ask questions on HelpHub. It's completely free. Your questions will be answered by a public benefits expert or an immigration attorney expert within 24 hours. So please look to HelpHub as a resource that you can use to get all of your public benefits questions answered and your public charge questions. If you want a deeper explainer about how the public charge rule affects housing and homeless assistance programs, I've listed a resource from the National Housing Law Project here. And then if you want deeper dives into public charge, I've listed the Illinois Coalition for Immigrant and Refugee Rights public charge webpage here. They also administer the Immigrant Family Resource Program. If you have clients who you want to refer them to a community-based program that they can help them with all of their immigration needs, please go to the IFRP website that's listed here on the second bullet. These IFRP partners are statewide and they can provide 55 different languages. So please go to that website to link your clients to community-based immigration legal services or social services. And then more resources are listed here. So when you get the PDF of the slide deck, you will be able to click on these to get links to more public charge resources. So with that, we have about 8 minutes left to answer questions. And if we happen to not get to your question, I will answer your question via email.
Thanks, Andrea. And we're actually doing okay. We're not being overwhelmed or flooded with questions. We do have a few minutes left, so if you have thought of something you want to ask, please type it into the question box on the control panel. We did get one question that's kind of a more general question. How can I best get an 18-year-old client approved for all kids or Medicaid? I referred them to the general website through the state of Illinois, but do you have anything else to say, particularly, let's say it's someone who's, would be subject to the public charge rule if the injunctions are lifted, and kind of, if they're in that situation today, what's kind of the talking points that we're giving people about how to proceed if you're like not currently enrolled in Medicaid, but you're thinking about doing it?
So right now, under the 1999 test, the Medicaid is not included in the public charge test. The new public charge test does include Medicaid, but it makes exceptions for Medicaid for children under age 21, so that would be the All Kids program here in Illinois, moms and babies, emergency Medicaid, and school-based Medicaid services. Also, remember that it's not kind of a black and white decision. It's not an easy decision because let's say, green card applicant who could be subject to the public charge test, there's so many different factors that go into that public charge test, not just their use or application for Medicaid. And so my advice would be if this public charge rule, if the new public charge rule gets implemented, that they talk with an immigration expert before making any decisions to disenroll themselves from a public benefit program, because it might not be to their advantage to do it at all. And certainly, going back to my Rosa example, if Rosa is subject to the new public charge test, but she has 2 U.S. citizen kids who are on All Kids, it would absolutely not be to Rosa's advantage to be disenrolling her U.S. citizen children from the All Kids program, because number one, the public charge test doesn't assess use of benefits by family members. Number two, All Kids is an exception anyway. So for many reasons, it doesn't make any sense. So it's complicated. That's why I also put the HelpHub registration page back up, because this is where you can go to get comprehensive information and answers to give your client about the intersection between, applying for Medicaid and public charge. So please sign up for HelpHub. It is free, and it's state-based. It's just here in Illinois, and we have over 2,000 registered users, and we have public benefits experts from across the state who answer questions. And you can also, it has a search function, so you can even search under certain topics and get your answer if that question has been asked previously. It's just a really great resource. You can see how it works on this slide. Can they see this slide?
Yes.
They can? Okay. Where you can see that even when this person asked a question about does workers' compensation count towards SNAP, it also points the person on the right hand of HelpHub to all of the related documents that could also be beneficial to the person asking the question or reading the question.
Thanks. And we do have a couple additional questions that have come in. They're both housing related. One of which is, do students that qualify for the McKinney-Vento Act, so that would be, I think, assistance for children who are experiencing homelessness and assistance they get through their school system, would that be considered a public charge?
So the only housing benefits, I'm going back to that slide, that are included, here we go, in the new public charge test that right now is blocked are those that are listed on this slide. If for McKinney-Vento receives a subsidy from one of these programs, then it could be implemented.
I don't believe that wouldn't apply, because this is really the kind of social service or transportation assistance that they would get from their public school. It's not any housing assistance at all.
Okay, so then the answer would be no.
And then a related question, I believe also the answer would be no. Are Illinois Hardest Hit Fund recipients liable for the public charge? So that was a program it's closed to new applicants, but it was created during the Obama era, and it was assistance through actually the Department of the Treasury for families at risk of foreclosure to help them pay their mortgage.
Okay, so again, if it's not explicitly included, then it's excluded. So that would also be no.
Okay, another question. Does this affect parents getting the child care assistance program for daycare assistance?
No, it does not.
And can I get a copy of the presentation? And yes, we'll be emailing those out, a PDF of the slides afterwards, and there'll be a video on our YouTube channel of the webinar you can share with your colleagues. And the last one was thank you. So I think we're all done, Andrea.
Okay.
So thanks so much for participating today. We had over 100 people on the webinar, so obviously there's a lot of interest and understandable concerns about this issue, but I think you gave people the information they need for the clients and consumers they're working with, or for them individually, to help them make a informed decision at the time of this constant flux and uncertainty.
I'm happy to help, and if any of you listening out there would like a webinar or a training for your organization, please just email us at pifillinois@povertylaw.org.
Thank you. So again, we'll be sending out the slides and posting a video, and we'll send you the links. Bye-bye.